good attendance at these events. Post-war Sri Lanka and analysis of human rights and potential prosecution. What we're going to be looking at this morning in 3 distinct lectures are issues of international criminal law, the major issues of law, what should be known, and also looking at the means that you can have international justice. There isn't a one-size-fits-all. And then we're going to be looking at a case that the international community did in the International Criminal Court involving one of our clients, President Uhuru Kenyatta, and you can see where they went wrong. So don't feel that the international community has all the answers. Sometimes the answers are within you, but there has to be a willingness to want to make those answers work. First of all, conflicts and crimes. We're here today because there's been a conflict, crimes were committed, and there are different ways of dealing with these matters once they arise. You've got your national procedures, which may involve national legislation for crimes such as murder, kidnapping, arson, destruction of property, your military discipline, your Armed Forces Act, Army Act, whereby there may have been breaches of military law, and you can handle all that internally. And then those are national crimes, and we understand what those are. But then you get crimes that are so big that they're called international crimes. And they become international crimes when there hasn't been a process within a state whereby someone's been prosecuted or justice has been denied, or there's been a failure in the justice system to prosecute. And the international community, looking at such crimes, is not concerned with the murder, with the this, with the that, although they may be concerned with a wholesale process of failure to prosecute. The international community has developed through something called universal jurisdiction, international courts that try international crimes. And they're not against the little people who've done this, done that, killed this, no matter how horrific the perpetration has been. They are for crimes of a bigger scale, and the international community has decided that in such circumstances there should be prosecutions. Now, we're going to look at the types of crimes there are, and universal jurisdiction is a particular matter we'll need to consider, because we're taking as an example the Second World War and the Third Reich and the Nazi Party. You had a big plan and policy that caused the deaths of wholesale numbers of individuals and great destruction. Those were called crimes that so offended the conscience of humanity that they were crimes against everybody's laws, even though they may not have been on the statute books of a national court. So, post-Nuremberg, the international community, following what was set up in 1945, which was the Nuremberg International Military Tribunal, tried one case. They took that example and began to create this concept of universal jurisdiction crimes that were so big that they offended the conscience of humanity. So, national courts may deal with some elements of this, but we get into the international arena when the national courts have not dealt with the crimes that have been committed. And so international crimes are listed in the Rome Statute, and we can look at them. They are war crimes, crimes against humanity, and genocide. They are the international crimes. There's another one called torture, which isn't an international crime, but there's a convention against torture, which states are able to exercise universal jurisdiction in respect of an offence of torture that's taken elsewhere, even though it hasn't been on the soil of a particular state. So, let's move on through this and now look at immunities. You've heard about the crimes in brief. What about immunities? Is anyone exempt from being prosecuted for these particular crimes? Well, the issue of functional immunity was looked at in a very important case at the International Court of Justice called the Congo against Belgium case. And it was acknowledged there that state sovereignty and customary international law had established that the holders of high-ranking office in a state, such as the head of state, head of government, Minister of Foreign Affairs, and those were just examples given in the judgment, were exempt from prosecutions whilst in office. So a very important matter of international law was decided in the International Court of Justice in The Hague, which is the court responsible for deciding disputes between states. However, there was no functional immunity, the court held, from international jurisdictions when you're out of office. So a former head of state, a former minister of defence, doesn't carry the immunity that he held whilst he was in office. The reason being, this is called functional immunity, and functional immunity allows the state to operate as a state because of the concept of sovereignty, and whilst in office, this is acknowledged between states how they function. So functional immunity is the expression that's used. Now, that immunity, as I said, doesn't continue whilst in office, out of office, and express provision is made within statutes of international courts that say keepers of high office or head of state and other senior political figures do not have an exemption from liability for crimes they may have committed in an international criminal court. So an international criminal court, because it's outside a national jurisdiction, is able specifically to prosecute incumbent heads of state. National jurisdictions can't do that because of the functional immunity. International courts can do that because it's an international crime, if that's what the allegation is. It has to be an international crime to come into that category. And just reading out some of the text of the International Court of Justice, I don't think I could put it any better. The court has carefully examined state practice, including national legislation, and those few decisions of national higher courts, such as the House of Lords, that's the Pinochet case, or the French Court of Cassation. It has been unable to deduce from this practice that there exists under customary international law any form of exception to the rule according immunity from criminal jurisdiction and inviolability to incumbent ministers for foreign affairs where they are suspected of having committed war crimes and crimes against humanity. Court emphasises, however, that the immunity from jurisdiction enjoined by incumbent ministers does not mean that they enjoy impunity in respect of any crimes they might have committed, irrespective of their gravity. Immunity from criminal jurisdiction and individual criminal responsibility are separate concepts. Jurisdictional immunity is procedural, criminal responsibility is a question of substantive law. Jurisdictional immunity may well bar prosecution for a certain period or for certain offences. It cannot exonerate the person to whom it applied from all criminal responsibility. And the upshot from the Pinochet case, which the International Court of Justice considered, was that he was found unfit to stand trial, which was a way that the then Foreign Secretary got out of a sticky political problem. So, international courts, though, do not suffer that particular burden because they have expressly in their statutes that any head of state or keeper of high office may be subject to prosecution, even though they are in office, because it's outside a national system, it's universal jurisdiction, therefore it's bigger than national jurisdiction. And that indeed was the precedent set at the Nuremberg International Military Tribunal, where Adolf Hitler had been alive. He would have been on trial because it said there was no functional immunity. And in fact, Admiral, got his name now, Dönitz, who was head of state for 18 days, was on trial. So that now is a precedent that has been set and followed throughout all courts. We're now going to be looking at the particular crimes that can be committed that come into this category of international crimes, you all being familiar with your own national crimes. Some jurisdictions have, within their national legislation, these particular crimes as being contrary to their statute book. The Dutch, for instance, the Swedes. So war crimes, as an international crime, is specifically within their criminal law legislation. And these are jurisdictions that have thought out of the box, if you like. They've thought beyond their own shores, they've thought about wider political issues, and they have incorporated the spirit of universal jurisdiction into their national laws. First we're going to look at is war crimes, and that's of particular relevance to the Sri Lankan conflict as to whether it applies or doesn't. So, war crimes law is what's called international humanitarian law, and it comes about from treaties as well as customary international law. And it has been a form of law between states for centuries. There's always been wars of law. You can go back to Roman times and Alexander the Great. Now, the prosecution of war crimes first took place at an international court, so not a national court trying war crimes, at the Nuremberg Major War Criminals Trial in 1945. And from there entered the mainstream of international jurisdiction, and then was taken up by the International Criminal Tribunal for the former Yugoslavia in 1993, And that became a court that wasn't an international court because it had several states involved, such as Nuremberg had Russia, France, Britain, the US. This was a court that came out of the UN, a creature that had been created in 1946 and now had grown with increasing influence to start to dictate international law to member states. So, war crimes occur during an armed conflict. War crimes don't occur during ordinary national situations of crime on the streets. It has to be an armed conflict. And a war crime is a serious violation of international humanitarian law. They are different crimes from those given specific definitions, such as genocide or crimes against humanity. So they are crimes that are called as such because they involve how military or armed forces conduct their military actions, or indeed organised groups who are not armed forces, so terrorist organisations or paramilitary organisations. They are all subject to the same areas of law of war crimes. And the substantive crimes such as rape, murder, destruction of property all come within that title of war crimes. So they very much reflect what would be within national laws, but they are specifically drafted to look at the wartime or conflict context. So the treatment of the sick, the treatment of prisoners, the treatment of religious buildings, the treatment of cultural buildings, etc. Because in wars and conflicts, those aspects of our life and society become targets which are not reflected in our ordinary daily lives. So specific areas of the conduct of military conflict or armed conflict become subject to laws. And these laws were developed in the Hague in the early part of the 20th century, late part of the 19th century. They're called the Hague Conventions, and there are two important ones. And then in the middle of the 20th century, after the Second World War, we have the Geneva Conventions, of which there were four with additional protocols. And so they were conventions to protect non-combatants particularly. And as I said, that's how the concept is expressed in terms of everyone knows you shouldn't kill people, harm people, but they're expressed in the way of being non-combatants, civilians. There is a distinction made between the types of people which give the context of conflict and war crimes, as well as people who have been shipwrecked, how you deal with them, and the sick as a result of war. So, war crimes law has two separate forms. It forms a body of rules for international armed conflicts, and then a separate body of rules for internal armed conflicts, because internal armed conflicts can be just as bloody as international armed conflicts. So in the Geneva Conventions, Common Article 3 and Additional Protocol 2 contain the very important rules for internal armed conflicts and how forces, be they official armed forces or organised groups, paramilitaries, terrorists, how they must treat the local population, property, life, etc. The rest of the Geneva Conventions and Hague Conventions only apply to international armed conflicts, but the founding fathers, noting the distinction, they weren't only dealing with wars between states, incorporated these rules to deal with organised armed groups as much as state military forces. And these rules don't apply to street riots or sporadic incidents. When there is a state of a conflict, particularly, it has to be in that context before these rules apply. And the determination of when a conflict starts is something that determines when they kick in, when they're triggered. So that is a matter of law and being, and in fact international observers often say this is a conflict now. We've moved from rioting in the street or a demonstration in the squares of Cairo to there now being two sides facing each other and a particular conflict. So, an individual, in fact, can have a unique defence to criminal responsibility for war crimes when he's under a legal duty to obey a superior, and where he or she did not know the order that was given to them was unlawful. And I read that out particularly here because that's a unique exception to what otherwise applies in international criminal law. We're going to move now from war crimes to genocide, called the crime of crimes. It was defined in the UN in 1946 and put into the Geneva Conventions. Genocide was not charged in the Nuremberg trial, nor any of the other Nazi trials of major war criminals or otherwise, because it had not been defined by then, and indeed, although as a concept it was known and had been discussed for several decades, it was the prevailing view at the time that another crime called crimes against humanity actually covered sufficiently and adequately the offence of genocide. So the drafters of the Charter for the Nuremberg International Military Tribunal at that time in 1945 believed that it was sufficiently covered in expression and context by crimes against humanity. It was a year later that Ralph Lemkin successfully put a specific crime of genocide into the UN, and it eventually became the subject of the Convention of 1946. So, genocide, how and when is it committed? The best definition really comes about from the International Criminal Court, which has its statute and debated at length in making that statute. Over 160 states were involved in the negotiations and discussions, and one can take that as reflecting customary international law. It's killing members of the group, causing serious bodily or mental harm to members of a group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, and imposing measures intended to prevent births